All right, let's get started. So a couple of things before we get going. One is strongly encourage everybody to please turn on your videos. It's a much more interactive session when we can see everybody's faces, and please utilize the chat window as much as you like. This is an interactive session. I'm going to ask questions, get your perspectives, get you to guess things, so that we can make the material a little bit more interesting and help it resonate so much more. So we're going to start with just going over some of the reflections from last week's lecture. I went through everybody's responses and they were really good. There were some really interesting comments. The common theme across all of the responses were that everyone recognised that the two witnesses that were presenting the forensic evidence were not qualified and were not presenting the information in an objective or an unbiased manner. There were a couple of really good observations. The one that I liked particularly was that the quality of the evidence didn't really reflect the severity of the charges. Julia Mero was confronted with possibly spending 40 years in jail for 4 convictions. And the quality of evidence that we saw, and was definitely common throughout all of the evidence that was outlined in the transcript, was that it wasn't really at a level that really showed the gravity of the situation. And I thought that was a really interesting point, which wasn't one that I had touched on my lecture, and really showed that the student had thought through the process and put themselves in the defendant's shoes. There were a lot of good observations around the lack of professionalism, the lack of questioning the evidence, questioning the analysis, and not validating the analysis. There was one really good observation that if you're going to present evidence in this manner, it should perhaps be done by multiple people so that you can corroborate that. In general proceedings, that can be the case. Both sides are allowed to engage their own forensic experts and are able to present their independent analysis of that. And then cross-examination identifies discrepancies or gaps or clarifies any of those discrepancies and gaps between the analysis. Another really good way to ensure your objectivity, and that's something that is very much practiced within the forensic industry, is validating your work with your peers. So you may not have 4 or 5 people presenting the information in court, but it would have gone through an iterative process with multiple peer reviews performed on the evidence before it actually got into a court of law, or that's what you would have expected if the level of professionalism is quite high. So I was able to read through all of everybody's responses. I haven't completed responding to everybody as yet, but I will get to that by the end of the week. I noticed a lot of responses. I know they're only due by Sunday, so if they come in, I generally kind of sneak them, the responses in during my lunch break on a Monday to try and get as much done before the evening, but I'm not always going to be able to get all the way through, so just bear with me. I will have the comments done over the next 1 or 2 days. All right, just having a look at the comments. We've got cheer squad from Adam, thank you. And I really do like Tim's view that we're going to direct questions to people who don't have their videos on. And everyone has started putting their videos on. Thank you very much. All right, so the topic of today's lecture is the forensic method and ethics. This can be a bit of a dry topic when it comes to forensics. It is, however, the foundation of a good forensic practitioner, and I'm going to try and make it as interesting as possible. So let's get started. So the first part is, what is the meaning of a forensically sound? Well, it basically means that it is going to be able to hold up in a court of law. So what does that mean? So it means that the digital evidence has been collected via a standard and documented and proven forensic process. So for evidence to be admissible, it needs to be defensible and repeatable. So what do we mean by that? Well, it means that there needs to be a clear description of how the evidence was collected and then what the analysis was performed on that. And it needs to be able to be demonstrated in a clear, articulate way with no gaps. That is especially important when demonstrating the chain of custody, that when you outline the custody or of when the evidence was actually obtained, and then the chain of custody during which time the evidence was within your possession, you need to be able to demonstrate that it is complete and accurate. In this way, it is defensible because when you are presenting your evidence, whether it be in a witness statement or on the stand, you're able to clearly demonstrate the process that it went through and describe the processes and the methodologies that you used to do that, and that it can be validated by a third party. So if you remember last week, Tim went through the process of explaining how you duplicate a hard drive and that it has there are mechanisms for validating that the data you collected is an exact copy of the original data. And then that process can then be replicated by any other forensic practitioner who may have cause to access that data or perform any further analysis on that. And so the point of that is that any analysis that you do on top of that is then admissible as well. Because if you get into a court of law and they dismiss the evidence that you've collected, it means that all of the analysis that was performed on top of that is going to be null and void. So if you think about the context of and the principles of your process being defensible and repeatable, what would you do in a scenario where there was actually no way, no technical way to collect evidence without modifying it in some way? The question is, would you collect it? And if you did collect it, do you think it would still be considered admissible? Yeah, that's right, Nico. So as long as you document everything, and not only and it's not necessarily the modifications that you have to document, though if you can, that is absolutely a valid approach. It's documenting your process. So if, for example, there is no way that you are able to create a full disk copy of a hard drive, and the only way to get the information that you needed was to create a logical copy of the whole hard drive or a portion of the hard drive. As long as you documented the rationale and then the process by which you followed to collect that evidence, then it would still be admissible in court. Another scenario where yes and no, Alexander. So the question is there open source software used for tracking these modifications, similar to how GitHub tracks changes to code? Not without actually installing it on the machine itself. I've actually never thought about it in that way before. Tim, have you ever come across installing a tool, say on your forensic machine, where it would track changes to the hard drive as you're imaging it?
Not for the purposes of imaging. There are tools out there that do it more for like malware analysis.
Yep.
But you're not so worried about the forensic integrity when you're doing it for that purpose. But no, generally not, because as soon as you have to install it, that kind of defeats the purpose. You want to be as light touch as possible if you do have to do something live.
Yeah, exactly. I've definitely installed software which does that. Say if you want to see what types of artifacts on a computer changes with the installation or the removal of certain software or drivers, then you can create an audit trail for those kinds of activities. But for a disk acquisition or the collection of data as evidence, it is documenting your process and explaining the rationale for collecting it in that manner. If you're collecting it via a forensically sound method and you have errors in the validation, then that error checking will actually highlight where on the disk it was unable to validate back to the original source. And then you can actually identify where, which sectors are affected. And then what you can do with that then is, even though the validation fails, because you collected the data in a forensically sound manner, if your analysis would still be admissible as long as none of the data that was used to perform the analysis was part of the corrupt sectors, for example, or didn't include the corrupt sectors. There still may be a case for that, but as long as you're transparent and you're clear as to why those sectors were corrupt, and you can demonstrate that you attempted to image that device multiple times and came with the same error, and then there are a number of reasons why that might be the case. All right. So there are principles of handling digital evidence, and these are the 6. So all of the general forensic and procedural principles must be applied. So that is basically what we just spoke through in the previous slide. You have your general process that you follow that are industry accepted in the standard acquisition of data, whether it be a drive or logical data, and you must apply those principles. Where there are exceptions, you clearly mark those exceptions, and then you select the most appropriate method based on the situation and the data that you're collecting. And then once you've seized that evidence, whether it is entirely forensically sound or not, then there should be actions taken that should not change that evidence. So there are forensic tools, or most forensic tools, or all forensic acquisition tools, have the ability to create a full disk image, or also have the ability to create subsections of a computer or a hard drive, depending on how it's presented to you. Either is it live, is it running live, or is it turned off? When it's necessary for a person to access the original evidence, that person should be trained for that purpose. So this is more relevant where the actual devices have been seized as part of the collection process and they are being stored in an evidence locker of some sort. If you need access to the original device, then you need to be trained to understand how to handle that so that you don't modify the original evidence in any unnecessary manner. And then any activity relating to the seizure, the access, the storage, or transfer of that evidence must be fully documented, preserved, and available for review. So basically, you need to have an evidence register. Every time you check it out, you sign your name with the date and time, and then and the purpose for checking it out. You keep your forensic notes, and then as soon as you've finished with that, you submit it back into the evidence locker or the location where it's storing the evidence, and then sign it back in again in the same way. Then any individual who's responsible for taking those actions with respect to the digital evidence and making sure, an individual is responsible for all the actions that they take on that evidence while it's within their custody, and any agency which is responsible for seizing, accessing, storing, or transferring that evidence is responsible for compliance with these principles. Basically, the whole point of this principles of handling is to make sure that you have an end-to-end audit process, that you can demonstrate where the data originated, the journey of the data throughout the analysis process, and then how it came to the output of that analysis. How much liability does the individual have? And would violation of one of these principles provide grounds for considering the evidence inadmissible? So the liability of the individual varies, depends on whether you're operating in, say, law enforcement or in a professional capacity. I'm not 100% sure what the liabilities are in a law enforcement capacity, but from a professional perspective, the organisations who provide forensic services, they do have professional liabilities built into their insurances. So if you can demonstrate that evidence in a particular matter, maybe one that was quite high profile, was tainted due to negligence, then there are liabilities there that may apply. But beyond that, that's a legal question. I'm not really sure from that perspective. But absolutely, violation of one of those principles would be grounds for considering the evidence inadmissible. It really depends on the nature of the breach of those principles. But basically, these principles are there that if you can cover off on all of those, then you're on really solid ground. If you can't cover off on all of those, you better have documented it very well and given very strong rationale. Otherwise, if it does go to court, there will be grounds for making that evidence and any analysis on top of that evidence inadmissible. So I'm going to give you an end-to-end example of an investigation that I was a part of quite some time ago. It was a search warrant that was executed in 4 locations in the home of a person called Mr. Paul Choiselet. Now, he was at the time quite a high-profile person within the Australian corporate industries. He was the director of 2 ASX companies, Q Limited and Jumbuck Entertainment, had a lot of influence, had a lot of political affiliations. And at the time, ASIC had evidence that he had committed or was involved in market manipulation, and he was concealing interests in shares of listed companies from which he benefited from financially. So it was a very similar scenario to the one that Tim talked you through last week, where there was multiple locations where AFP officers, ASIC officers, and forensic technicians were sent. And under the terms of a search warrant, we performed a very large-scale evidence collection exercise. But I wanted to use this as an example because, one, it's a matter of public record, so I can speak openly about the matter. The team I worked with were directly involved with searching, acquiring, preserving the data, and then later on performing analysis and reporting on that data in court. So I can describe the process end to end. And the work did culminate in needing to provide witness statements and getting subpoenaed by the court to attend. And basically it shows the importance of documenting the evidence and keeping detailed contemporaneous notes. And the witness statement that I ended up having to complete was quite short, so it fit on a slide. So it was a good example. So I'm going to go through the process. I'm going to talk through it more than anything else. And then we can, and you can ask questions as we go. So the process started with the seizure. So there was a pre-briefing performed to ensure everyone understood their roles and responsibilities. We met in 4 separate locations. I was lucky enough to be one of the people who met in a cafe, so I was able to grab a cup of coffee, which was about 5:30 in the morning. Other teams met in local parks, and one met in a plaza. So they all waited to execute the search warrants at the same time because we weren't quite sure when Mr. Choiselet was located, and we needed to ensure that there was no opportunity to tip anybody off or to perhaps obfuscate or hide any potential evidence. This particular case, the search warrants clearly defined the scope of this investigation and the seizure. So they were looking at market manipulation, they were looking at financial interests, and so ASIC had already performed quite an in-depth investigation and had a number of keywords that they knew directly related to the matter, and these were the keywords that we were going to search for on the devices. Now, these search warrants were time-boxed. So this particular search warrant had a 24-hour period, by which time if we didn't have the information that we needed and we hadn't provided valid reasons to seize particular devices, we had to leave the premises, and we may have need to revisit under a different search warrant at a later point in time. So when we arrived on site, the first thing that I did on my note-taking was to mark the date, the time, and the people that were present. And then I created a map, which I don't have anymore because a lot of my contemporaneous notes are actually in archive with the organisation that I worked for at the time. But we created a map of the site that we were at. We were at the office. And we found that fire exit maps are really useful for creating maps of sites. So you kind of wander around the site, get a feel for the rooms, and you keep a lookout for the fire exit maps because it gives a map of the floor plan and then notes where the fire exits are. So we generally copy one of those down with a pencil on a piece of paper and we mark out the rooms. And then we have discussions with people on site, understanding what each of those rooms were, whose offices they were, what were they used by. And then we go room by room to identify what electronic evidence is located within those rooms. Then each of those rooms, we make a list of all of the electronic evidence that we identified. And then using our forensic machines, which are machines that we would have prepared before going on site. So we would have wiped the hard drives on these machines, installed only those tools which would be required to collect forensic evidence. And we would have done the same thing with the hard drives that we were collecting the evidence to. There is a case for doing a full wipe of the hard drives that had been previously used, but in cases like this, we bought brand new hard drives and we use them for collecting evidence. So we would go through and we would collect the devices that needed to be searched. We'd hook them up to our forensic computers. We'd run the keyword searches, and then we would look through the results. Based on the search warrant, if we felt confident that the hits corresponded to a valid piece of evidence or a valid hit, then we would copy the entire device across to one of our prepared hard drives within a forensic image, and then we would validate that image. If we were unsure about the context of the keyword search hit, we would call across an ASIC officer. They would review the context in which the keyword was found, and then they would confirm whether or not it constituted seizing that data or copying that data across. We would take it at I guess, a risk-based approach. So we would have a look at who were in which offices within the building, and then those people who were of most interest, we would search those computers first. These people generally had EAs or PAs as well. So the EAs and the PA's computer would be the next cab off the rank for searching. And that way we would search the devices with the greatest chance of return. Then usually the unlucky person in the forensic team would get the servers that would be located in a server room typically, and then they would need to start looking through the servers and through the corporate data and collecting the folders within those servers that would most likely contain information of interest. So it is quite a long day. Like I said last week, one of the most important things is to pack snacks and plenty of water. And what we would do is if it started to become quite apparent that we were not going to be able to finish searching all of the devices that would potentially have data by the end of the search warrant, there is a condition within these search warrants where you're allowed to seize the devices for the purpose of copying them or forensically imaging them off-site. So it's not preferable because there is a whole additional chain of custody that then needs to be set up and maintained. But if you're getting close towards the end of the search warrant, then it is a really good way to be able to still collect any data that may be of evidentiary value. So the process of that is still needing to search the devices, but then as soon as you found a keyword, you then seize that device, you seize the computer with the hard drive or the laptop or the mobile phone. It gets registered in evidence tracker and then gets sealed into a non-tamper or in a tamper-proof bag, gets boxed up and then gets shipped to your office where you can then spend the whole night imaging that data to make sure that it can be returned at the time within 72 hours was the terms of that particular warrant. Throughout the process, need to keep acquisition sheets. Acquisition sheets is a pro forma template, which I actually forgot to copy across to the presentation, but Tim did send me a copy. And it then is used to document the make, model, serial numbers of the PCs and the hard drives that you're collecting, plus the date and timestamps that you collected that device on, and then the comparison of the date and time in real life compared to the date and time of the device that you're seizing. And the reason why that's important is because further down the track, when you are performing analysis, if the device that you seized was out of time, perhaps by 5 minutes, 10 minutes, 2 hours, an entire time zone, you need to take that into account when you're interpreting the data and the analysis. We have a question is, can these seizures last the full 24 hours in a worst case scenario? Absolutely, they can. Time is really super important in forensics. both the time it takes to acquire the data and making sure that you have everything that you need, and also then during the analysis process, which is why the forensic method is so important. So the forensic imaging can be performed on site or it can be performed off site, and all acquisitions are performed via an established forensic process. Yes, I did say that ASIC defines the keywords that allow for these seizures. So they're typically, in this case, Jumbuck was a keyword, Schwarzele was a keyword, some of his known associates were a keyword, some of the companies in which he had shares were keywords, and then there were certain locations where he had met with people which were also keywords, and you ran that across the tool. So there's the forensic tool, and you pull in a keyword list, and then you get it to just run across the hard drive. Often you would select the locations of the hard drive that you knew were a rich source of evidence, typically, so that you could get keyword hits as quickly as possible. If it was somebody's laptop of super importance, so maybe it was Schwarzele's laptop himself, you would start with the location where he has emails, and then where he has documents. And then if you still not get anything, then you might go into unallocated space, because perhaps he got tipped off and deleted a whole bunch of things right before the event. And then you start, and that would be picked up in a keyword search as well. Because if you did an end-to-end bit-to-bit search of a hard drive, it would take hours and potentially days, and that you don't have time for that under the terms of a search warrant. What are people's reactions to a search warrant? Angry, defensive, nervous, all of the above. I've had plenty of varied reactions, from shouting, screaming, to crying, and being very, very nervous. And you know what? That's pretty standard. It's something that you really need to take into account, especially when you have search warrants on people's homes where children might be present. It's something that you need to always consider, that these people are human beings, and not everybody on site is suspected of criminal or inappropriate behaviour. So the families may have no knowledge of the suspected behaviour. The work colleagues may have no knowledge. So it really is important to always be respectful, never be flippant, and never make remarks where you are presuming that the subject of the investigation is guilty. If you come across something that doesn't fit the keywords but could possibly be of interest to the case, yes, you're not limited to the keywords of the search warrant. What the search warrant is, what you are limited to is the scope of the search warrant. So usually it's worded along the lines of you can only seize electronic information that relates to the matter in which ASIC is investigating. And ASIC provides you a list of keywords to expedite that process. But if you find something outside of those keywords that's relevant to the matter, then that can also be seized well within the realms of the search warrant. Tim, what's been your experience in attending search warrants or attending sites like this? What have people's reactions been, and have you had any experiences where it's been quite difficult to find data in order to actually say, yep, we can collect this?
Yeah, well, the other thing I was going to raise was all the things that we're talking about with search warrants, they kind of apply to any time that you're heading out to a site to go and collect data unexpectedly. And in the corporate world, you do a lot of this when companies go into receivership. And it's a very similar experience where the people generally are not very happy. Their company is just folded. They know they're probably about to lose their jobs. So you get a lot of very different reactions. Even if you're in a corporate situation, you're heading out to investigate somebody within the company. I've had situations where people are just quiet and very accepting and very helpful. And I've had other situations where somebody's slammed a folder on the desk in front of me and stormed out of the office. So it can be hard to keep your cool in that situation, but it's really important part of the process to realize all those reactions are completely normal.
Yeah, that's actually a really good point, Tim. Yeah, a lot of our work is for companies that have gone bust. And it's really important to be really understanding and respectful to those around us. Yes, strange things have happened. I've had a gang turn up to a site where I was by myself to rob the place. I remember standing in front of the door and trying to stop them from doing it. In hindsight, I probably should have just let them steal things, but at the time I was determined to make sure that nothing got stolen. Because yeah, you come across all sorts of scenarios, all sorts of behaviours. So yeah, it's you learn to develop a pretty good poker face. If you come across there's a question on the chat, which is a good one. Actually, I'll start with Nico's. Is it difficult to make a relevance judgment call in less than 24 hours? The search warrant makes room for that. So it really is up to the ASIC investigator who's been doing the investigation for quite some time already to then make a call on relevance. There is room within the search warrant for capturing information that is where you're just sort of like 50-50, but it is part of the investigator, not the forensic investigator, but the case investigator's role to make sure that they are well enough briefed to be able to make a judgment call on the relevance of the data. Now, if you come across something that is not relevant to the matter which you are investigating, but is definitely indicative of a different crime, would that be grounds for another search warrant, or what happens there? Okay, so that's a really good question. So it really depends on the nature of the crime. If you find it's indicative of a different crime and it's criminal, then it would be up to the search warrant holder, which is typically a member of either the state or federal police, to make a call as to what the next steps should be. If it is child pornography, then it is definitely, the investigation is stopped, and then it moves into a completely different process where criminal charges are then explored. I've never come across that on site. I've come across that while investigating a computer under a different matter. And then that was just, the matter was dropped and referred to the police. I imagine it's a similar process if it was on site. Tim, do you have anything to add to that?
No, that's pretty much my understanding of it as well. But yes, reiterating, if you come across any material of that nature during your investigation, it's always tools down at that point. And again, I've never had it happen on site. I've only ever had it happen in the lab. But as soon as that happens, everything stops and the police get called in immediately, essentially because you don't want to commit a crime in the act of trying to investigate it any further, and it's not your job to investigate it at that point.
Yeah, that's right. It is illegal to be in possession of that kind of material. So as soon as you identify it, if you don't report it to the police, then you are considered to also be in possession of it and breaking the law. So let's have a look at a actual report or a statement, a witness statement. So this was, oh, that's not coming up very well, is it? Apologies for that. It looks much better on my screen. I hope it's legible on yours. So this is a statement, and this is a statement that I had made based on some very specific laptops that were seized. Now, we seized, I think, across all of the sites, there were probably about 30, 35 devices, and I don't know how many logical images of data from servers and mobile phones and USB sticks, but there was a lot of data. The actual relevant data that went to court was located on these 3 devices. Sorry, I should rephrase that. Of the evidence that was relevant and made it to court, 3 of those devices I imaged. There may have been other devices that were imaged by other people. I was the head forensic investigator on site, so I was overseeing the investigation. So one of the devices was captured by one of the members of the team. Now, if you have a look at the statement itself, you can see that I explain what my credentials are. So I explain what my title is, that I work in forensics, that I have held my position for 2 years. Even though I'd worked for the organisation for much longer, I had to be very specific that I held that position for 2 years, and that I had 10 years of relevant experience, and then I list my qualifications. Now, if you think back to the lecture last week, you can see the difference in the way that my qualifications have been presented versus the way the qualifications of the two witnesses were presented. And then I go through and we explain we're engaged by ASIC to assist in the matter of Mr. Choiselet. Now, having a look at this witness statement, what are some things that strike you? What do you observe around the information that is included in this statement? Besides my middle name, yes.
Sorry, one thing that I sort of saw was the explanation of like what are forensic images.
Mm-hmm.
At the bottom, I think point 9. Just would this statement be sort of read out in court, or is it literally just submitted to as a witness statement?
It would depend if I'd need to present the evidence in court, but yes, I would. That is one way to explain the process. We'd probably put a little bit more context in it if we were actually presenting it in court as a witness. But for the purposes of a statement, this is sufficient. It was sufficient in this case. It really depends on how important, it depends on whether or not the collection is contentious. So if the collection itself was a matter that was being scrutinised, then you would go into a lot more detail around this. There are expert witness statements that I've submitted, or expert reports that I've submitted, where I spend a half a page explaining what a forensic image is and what is the importance of collecting it in this manner. So it really depends on the context. They just needed, in this instance, to demonstrate that these devices were collected, not necessarily validate that they were collected correctly.
Okay.
Yeah, that's a really good question. And I did have lots of snacks. I was actually known as the person to go to for snacks. I always had snacks because I'm always hungry. The one thing that I would point out is you can see that my witness statement is dated 2012. Can you remember when the search warrant was actually executed? Yeah, 3 years earlier. And I created this statement at the request of ASIC 3 years later after the fact. Luckily, I was still working for the same company, so I had access to all of my contemporaneous notes, all of the imaging sheets, all of the on-site documentation that was collected. But if I go to the next page, you'll see this is the subpoena I received. You can see that's dated 2016. So there is a large gap, one between collecting the evidence, one writing the witness statement, and then actually presenting it in court. So what do you think then around the importance of the forensic process, given that the legal wheels turn slowly? You need very comprehensive notes. And your personal notes also need traceable chain of custody. Not in consulting, I didn't have that. Mind you, I always had my notebooks dated and time-stamped. Well, I at least had them dated. And then when I was keeping a record of activities on site, I would create a column, a thin column down the left-hand side of the notebook, and I would time my activities in that way. So yeah, exactly. You should always be documenting. And do you lock up your notebooks? Actually, no. The only time I did that was when I worked on a criminal matter that was quite high profile, and I chose to do that. But I didn't lock up my notebook after every shift. Mostly because in consulting you don't have shifts. You basically work 24/7. But I would keep them in my drawer, and for live cases, I actually would lock them in my bottom drawer or leave them in the locked lab. So often when you're performing an investigation and you're performing analysis, I don't know about you, Tim, but I got locked in a windowless lab where I would do a lot of my analysis and would leave my notebooks in that lab. The forensic lab was actually really important because it was locked and you couldn't get in without a key code or later on a pass swipe, so that only certain people could have access to the evidence, and it could be tracked who had access to it at what time. So you could produce audit trails of of the comings and goings of people within that lab.
In the end, we started printing out loose leaf contemporaneous notes forms so that you could file them with the case rather than taking. So I don't necessarily take a notebook around with me anymore. I take a set of loose leaf contemporaneous notes forms that I then can file with the case to make it easier to leave them in the office so that they're associated with that case. Which means you don't have 1,000 different books with different people's notes associated. But some people still take notebooks as well. Both is fine.
Yeah, I think I started doing that towards the end too. When I was heavily involved in this industry, it was still very much developing. And I think for the last few years, when I was performing investigations for a living, I did something quite similar, just because, you know, ripping pages out of notebooks and then popping them in case boxes was, you know, it wasn't the neatest and it wasn't the most easiest to keep track of. So yeah, I started doing similar things, Tim. Question, did you write your qualifications as of 2009 or 2012? It was 2009. So at the time that I wrote the statement, at the time that I wrote the statement is when I did my qualifications. No, let me just check that. I'm just going to go back one. Let me just read that. Lost my mouse. There we go. Let me just read that. I've got this position for 2 years. And practice for 4.5 years, and it was 2012 when I wrote that. So no, that was at the time of my statement. That was my qualifications at the time of the statement. Yes, Adam, it really goes back to defensibility. So does loose leaf notes affect chain of custody? I've heard legal people prefer bound books. Now that you say that, I don't remember ripping pages out of my books. You had one book per, especially if it was a search warrant, you'd have one book for that search warrant, and then you wouldn't write in anything. You're absolutely right. I completely misspoke. Actually, one of the things that we were always told not to do is to mix up your evidence notes within a book. So you would have one notebook per investigation, and you would ensure that you kept your notebook clean, in that you wouldn't cross over investigations. So one notebook per investigation. All right. Any questions around that in particular? So the other thing I wanted to comment on is that given the search warrant was executed in 2009 and the statement was written in 2012, the imaging sheets that I was referring to before are basically the reason why I could fill in those boxes. So the device, make, model, and so forth, those serial numbers, the size of the hard drives, the ASIC property barcode, for example, I could only fill in those details because I had kept very clear, strict notes on everything that I did. And then even subsequent analysis was exactly the same. Where I hadn't made exact notes of the time, I would write approximately. So you could see that on the 23rd of September of 2009 at approximately 7 a.m., I attended the premises located at the address that was given of the office. And then further down the track at approximately 7:30 a.m., ASIC directed me to a laptop bag containing the laptop that was located at the premises. And what is not in the statement was that there was a map that actually I had written on. So every piece of evidence that you collect, you give an evidence number. And on that map, I would write the evidence number in the location where I had collected it or where I had found it. I really wish I had the map. It would really show the kind of detail that you go to. All right, so the next part then is ethics. Ethics can be a bit of a dry topic, but I think it's actually quite interesting in the realms of a forensic investigator, because sometimes you can be ethical in your behavior, but not necessarily moral, or you could be moral in your behavior, but not necessarily ethical. So the difference is that ethics are moral principles that govern your behavior in conducting a particular activity. So in that regard, usually industries set up ethics themselves or an ethic code of conduct, which they would expect members of that industry to adhere to. Morals is really as standards of behavior. It's your principles of right and wrong, and is normally set by, is normally shared by your community, your religious group, your society. It's more cultural based, and is the day-to-day code that you would generally adhere to in your life. So questions that can help guide an ethical decision with regards to forensics are listed there. So these are things that I even use today. So working in cybersecurity, I often think, if this decision was on the front page of a newspaper, would I be happy with that decision? Would I be able to defend it? Is there an ethical non-negotiable within this decision? Is it legal? Is there a law that I'm going to be breaking? Will my actions impact the greater good? What would happen if everybody made that decision? Would it result in the total sum of good, or would it actually be worse? Would result in a situation being much worse? What would it do to my reputation or the reputation of the people I work for and with? And is it consistent with my moral code? So let me put an ethical/moral dilemma to you. What would be your answer if you were asked to defend a terrorist? If you were asked to analyze electronic evidence that, on behalf of the defense team for a suspected terrorist, would you accept the case or would you decline the case?
Probably decline.
Yeah. It'd be ethical. Yes, someone does have to do it though, you're right. Yep. You might accept the guy might be innocent, presumption of innocence. Yes, you can absolutely decline a case. If you don't want to act as a forensic investigator or be an expert in a case, you can absolutely decline it. Yep, it could produce biased views. That's a very good point.
One thing, could you sort of weigh up your own worth as an investigator in this? So if it's a very like high profile thing, could you say, I'm not comfortable with sort of being able to do this justice, and then say someone better qualified could do it?
Absolutely.
If you
It's actually
don't feel that you can do it yourself.
Absolutely. It's one of the elements of ethics that it's really excellent point. Further slides actually address that you want to make sure that you operate within your own competency. So let's say that, so people are on the fence. Yes, could presume innocence. No. Let's say that there's very strong evidence that this person has committed a terrorist act, and going through the process of the courts is executing on due process, but this person was pretty much caught. What would you say then? Would you act as part of the defense team in presenting electronic evidence? No. The reason I ask this is because I was actually put in this exact predicament. So one of the first cases, one of the early cases tried in Australia, I was asked, actually that's very true, Paneeth, and actually that's what I'm going to get to. So as long as you're following the right procedures and not doing anything wrong, I don't see why we shouldn't defend someone. And this is where it is an ethics versus morals dilemma, right? And it's something that you need to face into when you are a forensic investigator. It's ethical to present evidence as part of the defense team for somebody who you, in your mind, may have committed a heinous act or a heinous crime. But perhaps for you, it's not morally acceptable to represent them. And I was asked to defend a group of suspected terrorists. There were 4 of them that were convicted. It's quite a popular case. I won't speak too much about it because the matter of the case isn't really what we're discussing now. But I was asked by my boss to assist in defending these terrorists. And my initial response was, no, I'm not doing it. So then he sat me down and he said, I understand, and you don't have to do this, but let me tell you why I'm accepting it and why I want you to help. The Department of Public Prosecution had engaged a number of forensic investigators to assist with presenting the electronic evidence as part of the defense case. And everybody had said no. Now, if nobody agreed to present the evidence, there was potential case for mistrial. They weren't going to receive proper representation under Australian law, and there was potential for properly prosecuting them and for the crimes that they committed. So at that point, my moral view of the situation changed. In actually assisting the defense team, I was actually assisting in prosecuting them. And so therefore I accepted the case because it aligned not only with the ethics, but also my moral code. It was a tricky one. It was one of the very first cases. Terrorism hadn't really entered into mainstream society. It wasn't something that was well understood, well known, and investigating it was actually quite disturbing because they were guilty and there was a lot of material on their laptops that was of a very graphic nature. But in the end, they were convicted. And I feel quite comfortable in the decision that I made now because I know that that may not have been as easy to do if we hadn't have assisted in representing the electronic information. And what I took comfort in is that as a forensic investigator, you act on behalf of the court. You don't actually act on behalf of the defendant or the prosecutor. Your duty is to assist in the proper execution of justice, and therefore you are ultimately accountable to the judge. And therefore your information, whether it supports the defense's case or the prosecution, needs to be presented in an unbiased manner. Exactly, Abby. You have to be honest in your analysis and you have to be unbiased and objective. So we found a lot of material that indicated that they had plans for terrorist acts, that they had been sharing videos of previous executions and so forth. And so we needed to present all of that in a very objective and independent manner, which we did.
How's that really been on the defendant's side, though, if your goal is to just, put everything forward as it is?
because they will have different instructions to the prosecution. So the defense will give you a list of instructions that you need to answer, that they are going to then use for their case. And then you are then guided by those instructions. Now, those instructions are not allowed to bias you. So if you perform an analysis and then you present that the results of your analysis based on those instructions, if that information doesn't support their case, it is illegal for them to bias your evidence. Sometimes you will have lawyers try and instruct you to word things in a certain way that makes it more, I guess, more compelling for their case, and that is not allowed. It's illegal. Both for from the lawyer's perspective, they're not allowed to instruct you in that manner, and both from a practitioner's perspective, you aren't allowed to accept instruction in that manner.
I see. Okay, thanks.
Did you face any criticism for taking on the case? I actually didn't tell anyone at the time. My work colleagues knew because obviously they were around, but I didn't tell anybody. I didn't tell my friends. At the time, I didn't even tell my family. I can't quite remember if I was under any extra form of confidentiality agreements, but I know that that wasn't something I particularly wanted to share at that time. Does dishonest lawyers happen often, or are most honest and upstanding? Look, most of the ones I've worked with are pretty great. I think where you get to the more interesting, so your solicitors are pretty great. They know how to work with consultants. Where you get really interesting experiences is with your QCs and your barristers. Like they're a different type of human. They're wickedly smart, but able to poke holes in absolutely anything and everything you say with very minimal input. They're very good at what they do, but they're a very interesting group of people to interact with. But for the most part, lawyers are pretty honest and upstanding. They have their own code of ethics to adhere to. So, yeah, on the slide there is a reference to the code of ethics that is set by the International Society of Forensic Computer Examiners. There are a number of codes of ethics now for computer investigations, but this is the one that is most widely accepted. So I understand we're going over time a little bit, so I'm going to try and go through these really quickly and just stop for any interesting. Is there an example that is moral but not ethical? Not for me, because then I might be opening myself up to liabilities. But if you want to think about computer hacking, for example, right? I think that's a really good example of something that you might find is within your moral code but is unethical. So there may be very good political reasons for hacking certain systems or performing a hack or being part of hacking groups. If you think about the state-based hacking groups across the world, Korea, Russia, China, they would be acting according to their own set of morals, but it would generally be considered unethical for them to be performing that kind of activity. Anonymous is another example. They sometimes get behind some really, I guess, worthwhile political causes, but so while for themselves they would be acting within their own moral codes, the harm that they do or the actual hacking activities that they do would be considered unethical. All right, so if we think about ethics, there's a number of components that we need to consider. So honesty and competency, and this comes back to Philip's comment around, are you competent to be able to perform a particular, or to assist with a particular case or to perform certain investigations? It's also about representing your experience and your level of experience accurately, and then continually developing your skills and your expertise. Within computer forensics, there are a wide range of specialties. I know when I was working, I specialized in Windows systems and networks and Apple iPhones. I know that's a kind of a strange intersection, but a lot of my work was around those two types of systems. And so I built quite a high proficiency in that and started to do additional research into those two areas of computer forensics. Now, that didn't mean that I wasn't capable of performing investigations on other types of systems. I was, but I was acutely aware of my limitations, and I either performed research and analysis or more in-depth analysis to validate my findings to compensate for that, or I would get peers to help, or I would get peers to validate, but I would never overstate my capabilities within a particular investigation if I wasn't specialized in that particular area. And that's why it's great working in teams, is because everybody tends to lean towards different specialties. And then when you're in court, you need to then be honest with your analysis and your findings, remain independent, make sure your evidence and the analysis you present is relevant, reliable, it's sufficient and persuasive. So relevant, is it a piece of the puzzle that you're trying to solve? Reliable, does that puzzle actually belong? Is it sufficient? Do you have enough pieces to accurately represent what you are presenting? And is it persuasive? Can you explain the process? Can you explain with technical depth why this particular analysis is relevant to the case? Understanding legal boundaries in which you operate. So making sure that evidence you obtain is legal and that you follow proper process and when you're handling evidence, and understanding the standards of proof. Obtaining evidence legally is a bit of a tricky one sometimes when it comes to computer evidence. Actually I might just throw to Tim because I need to take a sip of water. Tim, what's a really common boundary when collecting electronic evidence when it comes to, say, the Telecommunications Act?
I was just going to say, we're going to talk about the cloud later on tonight, which really stretches the idea of legal boundaries. And I've forgotten the word because I always forget this word. Help me out here, Tabs.
I don't know.
Jurisdiction. That's the word I was looking for.
Yeah.
We're going to talk about that later today, where that's sort of taking an act that was meant for physical evidence and stretching it right to the extremes of how it's interpreted.
Fabulous. Well, then I won't elaborate on that, other than there was a particular case that I was working on. We'd actually executed a search warrant on a criminal matter. We were investigating a drug dealer, and we had, I was working on the mobile phones, and I noticed that there was a mobile phone that was beaconing. It was a Bluetooth beacon, and I had the ability to connect to that phone and pull information from it. But the search warrant, the remit of the search warrant didn't include the car. And therefore I was unable to collect information from it because we determined that the phone was actually located in the vehicle rather than in the house. And the vehicle was parked in the neighbor's driveway rather than their own driveway. So if the vehicle was parked in their own driveway, we would have been able to collect it, but it was actually their neighbor's driveway. So it was outside the scope of the search warrant. So it was something that we weren't able to collect. So remaining objective, so being unbiased, not to be unduly influenced by either the information outside the scope of the investigation or incomplete evidence, which kind of relates back to the case that we were discussing last week. It's really easy to impact your objectivity. People's laptops are basically their diaries, right? So you can learn a lot from somebody's laptop, learn a lot about them. You could think about it, if you're investigating somebody for, say, white-collar crime, maybe they embezzled money or maybe they committed some sort of fraud, and you start reading through their emails because you're looking for evidence, and you find that this guy is horrible to their friends and cheating on his wife, and there's evidence that perhaps he is unkind, or I'm not going to go into any more details because I have a particular case in mind and it's a little bit nasty. It's really easy to be biased by that but it has nothing to do with the case at hand. It's got nothing to do with whether or not he committed fraud, but you learn about all of these things about them that you start to go, well, this person's awful. Then you start to allow that to cloud the way that you're interpreting evidence. So you might find an email fragment in unallocated space that you're thinking, well, you know, that clearly indicates a crime, but actually if you take it objectively, then it may just be something quite innocent. Conversely, and I've had this as well, you're looking for somebody who has committed a crime, and yet you're going through their emails and this person is a pillar of the community. They get involved in community initiatives, they coach their son's soccer team, they are loving and kind to their wife, and you're thinking, man, this guy couldn't have committed a crime. He's really, really nice. And so that might actually stop you from doing that extra layer of analysis, that extra level of digging that might ultimately reveal that that person is implicated in committing the crime that they are accused of. But you may not have gotten there if you'd allowed yourself to become biased by information outside the scope of the investigation. So independence and integrity. So you need to ensure that you're independent. Avoid conflicts of interest. The investigation that you may be a part of or may be asked to become involved in may involve a personal relationship, financial interests that you have, secular relationships. They may not necessarily preclude you from performing the investigation, but you do need to disclose them. You need to be very transparent. I will think about it. I mean, what would you consider if you have, actually I might just answer it because we've got a really short of time, but you might need to have extra considerations if maybe a family member or a friend asked you to assist in a matter that required a digital forensic investigation. I've had that myself in some very sensitive matters where I've assisted somebody who's quite close to me in performing a forensic investigation, which was then ultimately submitted as evidence. But from the very beginning, I was very transparent with the police. This person is a friend of mine. I have a personal interest in this. And so made sure that the analysis was I was very objective in my analysis. I stuck to the parameters of the instructions, and everything was validated by an independent third party. Must keep all of the information that you collect confidential. Like I just described, you become privy to information that is deeply personal to people. And it is really important to keep that information confidential. Also, you are given access to perhaps commercially valuable information. I've worked for organizations whose value of their company is based on intellectual property that is stored in secure locations on their computers or their servers, and you have access to that. So it's really important to maintain confidentiality. There might be legally privileged information where if you actually share it in the wrong way or accidentally disclose it, you void legal privilege. And then of course there is personal sensitive information which you are morally, ethically and legally obliged to keep confidential. A really interesting conundrum is where you actually, I remember a case where I was doing an investigation for a former employer and was investigating something completely innocuous. They just wanted wanted to see if there was any evidence that somebody had been committing fraud. And the team that was managing the relationship of this person, I knew that person. And one of my dear friends was married to that person. And in the course of that investigation, I actually found out that this person was cheating on my friend. But I actually couldn't reveal that information. I was bound by strict confidentiality clauses and contracts because this was especially sensitive, and I wasn't able to tell her. And so you do sometimes find yourselves in these very difficult situations. I know, yes, Netflix material, I couldn't believe it. Yeah, it's really important to adhere to this, because if I had breached that confidentiality, then I left myself open to scrutiny, if this got to court, potential professional implications, my reputation could be ruined, I wouldn't be able to get work. So there's a lot of value in adhering to ethics. And then just generally being a good human, respect for your colleagues, don't badmouth peers, willing to share your knowledge in publications, mentoring, presenting, teaching, and doing it responsibly. And then also social responsibility, contributing to the greater good, whether it be to the knowledge that of the industry itself or doing pro bono work. And then just again, that human consideration that you are investigating human beings and that your actions can have far-reaching and long-lasting impacts. So a couple of questions coming in. So is that confidentially continuous or is it for X amount of years type of thing? It is usually, it varies. It could be for the life of the matter. So until it becomes a matter of public record is generally what we go by. So we don't talk about cases openly unless it is already a matter of public record. There are situations where you can talk about those things, either whether it is to improve the industry or to because the information might serve the greater good. And there's something called Chatham House rules, where you can claim Chatham House rules in forum, which means that you can share the information with the people in that room, but they can't share it any further. But then there's also for the greater good or for the execution of justice. If you come across something that is criminal in that investigation, then there's always, you always have to report that then. And then that's not breaching confidentiality. That is just following the legal requirements of a forensic investigator. For personal information specifically, for personal information, I actually just defaulted to never sharing it. Tim, I'm not sure about the legal.
I'm not sure either, but I'm the same as you. I think a really good mark of how seriously people take this is whenever any forensic team that I've been in goes to a stand-up meeting with their colleagues, most of the time, the only update that will come from us is, we've got a job on, but I can't tell you about it. And that's because we all know how important that is. So yeah, I certainly personal information, even if there was a rule, I don't think I would release it anyway, because we're just privy to so much information. I would think about if somebody was investigating me, whether I would like them to have the same amount of respect for that information. So yeah, I follow the same rule generally. If once it becomes a matter of public record, that is, it's been through a court and it's actually on the public books, then I'm happy to talk about it. But aside from that, I generally won't talk about it at all. And unfortunately, you get a lot of stories from me saying, I'd love to tell you about it. It's interesting, but I can't tell you because I'd have to kill you.
Yeah, I'm the same. You can be vague, like you can talk about things without naming companies and people and locations, but sometimes the cases are so well recognized that you don't even do that. In a case like that, if the investigation has already begun, are you allowed to stop midway if you think there may be some bias, or is that unprofessional? No, that's actually the complete opposite of being unprofessional. That's being professional. And that has happened in the past as well, where, you start an investigation and then you realize that you aren't necessarily independent, and that's when you call it out. And sometimes the conflict of interest warrants you being taken off the case. Other times it's noted in a register, and then that is and that's known throughout the process, and it's very transparent. It might preclude you from performing certain types of analysis or presenting certain types of analysis in court, and then you just accommodate for that where it's appropriate. All right, I've gone over again. I'm sorry, Tim. Shall we take 5 minutes?
Yes, please.
Yep, cool. Thanks, everyone. Feel free to continue asking questions in the chat. I can just respond on the chat. But thanks for your time.
I'm just going to get a drink before we start up.
Cool. It's a good question, Aaron. I'm not sure. If you carried out all the investigations as you should, would being biased actually change the results? I think you always are biased in some way. I think it's about recognizing that you are and making sure that you remain objective anyway. I think it is being human that you become biased. It's just practice to make sure that you're not unduly influenced by that bias. I went to type my answer, but it's much easier to just say it. I would agree that you are always going to have a little bit of bias. I think that you've got to fall back on what's your process, what's your analysis. As you gain experience, depending on what your instructions are from the lawyer, you kind of get a feel for where you're going to start your analysis, what type of analysis you're going to perform, and how you're going to validate that. I think there may be some instances where you would feel extra motivated to pull out evidence and find obscure evidence because you thought that the nature of the investigation was particularly terrible and you wanted to help as best you can. But I would like to think that for the most part, you know what you need to do, and if you do it well, generally the outcome should be the same, whether or not you have a personal bias on the investigation or not.
All right. So we get a start? Can everyone see my deck, my slide deck? Are we good?
Yep.
Yep, awesome. All right, let's go. All right, so we're going to cover, so moving on from last week where we talked about some of the prep and on-site stuff, we're going to now look at disks. We're going to look at the physical disk structure, the logical structure, a few different areas that exist on disks where data can be hidden. We'll talk about unallocated space and slack, and a little bit about deleted items, although we'll talk more about those when we talk about file systems. And then we'll also look at complex scenarios, so RAIDs and clouds, and why they're a challenge for us. So why are we going to look at this stuff? I'm sure some of you have already gone through computer courses already, which talk about how disks work. It's important for us to understand how these things operate so that when our tools do a lot of the heavy lifting for us, we're able to understand what our tools are doing in the back end. It's not likely that you'll ever need to go through a hard drive and manually recover data from it. Your tools will do a lot of the heavy lifting for you, but you need to be able to understand what that tool is doing, and you need to be able to replicate it in some cases and validate it. And you also need to know when your tool is throwing you up an odd result, so that you can go in there and have a look at why that result has come through, and whether something that the tool hasn't considered is potentially occurring in the back end. Right. Traditional drives. I call them traditional drives. I guess now they're actually getting to the point where there are old legacy drives. But your standard platter drive is what I'm talking about here, magnetic drive. So they're arranged into platters, and then inside the platters you've got circular tracks, and then inside of the tracks you've got sectors, and the sectors are the smallest addressable block of storage on a drive, so you can't address anything smaller than that sector. Thankfully, we don't have to address physical sectors by their platter, track, and sector. The software and firmware takes care of that translation for us, and we get a lovely scheme called the LBA scheme, which is just a sequential number from 0 to whatever high number, depending on the size. And that takes care of all the layers of abstraction between us wanting to locate some data on the drive and it needing to translate that to what platter it's on, what sector it's on, what track it's on, and doing all the head seeks and things of that nature. Prior to LBA, there was another addressing scheme called CHS. In your own time, you might want to look up what that is. There's still traces of it in some of the structures, even today, on disks that are still there, particularly in the MBR, which we'll talk about it. One thing that it's really good to remember at times is that on platter drives, it's advantageous to store the data in contiguous sectors. So that means having a file all in one place on the disk. Who remembers defrag? Has anyone here ever had to defrag their computer or defrag their computer? Oh, wow, people still do that? Okay, I haven't defragged my computer in ages. And in fact, most of the time, the computer now stops you from defragging because it's actually a bad thing for a lot of modern drives. So I remember sitting at home looking at this screen, enjoying all the red turn to blue as it moved around on the disk, and get that feeling of satisfaction at the end of doing it when you had more white and no red, and always getting frustrated at that little green bit of unmovable files and wondering why it was unmovable and why I couldn't get more space by moving that unmovable files. So why did we used to defrag? Adam defrags SSDs. All right, we'll talk about that in a second. Why did we used to defrag? Yeah, better access times, right? So it's a physical drive with a read head. It takes less time for it to read data off the drive if it can just do it in one big stripe rather than having to seek randomly around on the drive. So that has some really big implications for us when it comes to data recovery. And we'll talk a little bit about that later, but knowing that at least on platter drives, that all of the file is, or the OS is going to try and put all of the file in a contiguous slot, means that when we find the front of the file, there's a good chance that we'll probably find the whole file following it. So we'll talk a little bit more about that when we get to data carving, but that's an interesting aspect to old style drives that it's always worth remembering. Of course, now the old platter style drives are starting to go out of fashion, and we're seeing more and more SSDs coming around. Particularly, we really are starting to see the old style drives disappearing into things like NASs and large storage, which we don't deal with as much as we do with laptops and PCs. And of course, laptops and PCs now are mostly having SSDs installed in them. In fact, I think the place where I work now, most of the fleet are all SSDs. They're all M2 SATA SSDs that we deal with, which is really good for imaging times because you get really great write times off them. But it has a couple of implications as well for the type of data we can get off it. So SSDs still use LBA addressing, even though the translation to cylinders and heads and that don't really apply. At least then we have a consistent addressing scheme that we're accessing the data off. We don't have to worry about differences between SSDs and platter style drives. But with an SSD, there's no distinct advantage to contiguous storage, right? So the seek time on an SSD is the same no matter where on the SSD the file is stored. So you don't need to move the data around and get it into one chunk. In fact, it actually can be to your disadvantage to do things like defrag. Does anyone know what wear leveling does on an SSD and why we have wear leveling? No one heard of wear leveling before? Yeah, to save cells, basically. So like an SSD, each cell, if we want to call it that, has a limited number of times that you can write to it. So if you're putting all of your data in the same place all the time, you're wearing out that part of the SSD while you're leaving the other parts of the SSD unused. So in order to try and combat that, algorithms were introduced into the SSD firmwares and controller firmwares to try and even out the usage of the SSD. So it's going to intentionally use random spots on the SSD to make sure that the SSD is wearing out evenly. If you go and try and defrag an SSD, and I'm pretty sure, Adam, it actually prevents you from defragging SSDs in the OS layer at this point. You're actually undoing, well, you're not achieving anything because the wear leveling in the background is forcing the data to go where it wants it to go rather than where defrag wants it to go. So again, if we're thinking about recovering data, we know now that data on an SSD is not necessarily stored contiguous, so just finding the beginning of the file isn't going to necessarily mean that we find the rest of the file after it. And indeed, we have a lot of trouble with data carving on SSDs. You tend to only find the smallest of files on it because of this wear leveling algorithm. Oh, Windows 10 allows defragging SSDs. Okay, well, don't do it. It's not required or necessary or useful. I'm surprised it still lets you do it. Okay, so these are two very old things now, actually. I haven't seen these in quite a long time, but just because it's old doesn't mean that you won't come across it. And it's still really important that you're aware that they exist so that when you see the telltale signs of them, you know that you are potentially dealing with one of them. So host protected areas and drive configuration overlay were two ways that drives could appear smaller than they actually were. And this is something that you, as a forensic investigator, you want to be aware of, mainly because if somebody can make a drive appear smaller than it is, then they have potentially a place where they could store data in that area that's larger than the drive is saying that it actually is. They weren't intended for nefarious purposes. They both had very legitimate purposes. So the host protected area was a way of combating early BIOSes that couldn't deal with very large disks. So essentially, the drive would boot and report to the BIOS that it was a smaller drive, and then it was up to the bootloader to reset that so that the OS could read the full size of the drive. So that's a fairly legitimate purpose. And DCO was a way for vendors to purchase hard drives from a whole bunch of different manufacturers and then make the size of the drive consistent. So I think the example would be a data center wanting to get a whole bunch of drives of the same size and purchasing them from different locations and making them all appear, at least to the software, as if they were a single same size for the purposes of putting a RAID together or something like that. So this comes to a really good point about something we should do whenever we've just finished imaging a drive, and it's verifying the sector count. And it's important that we do this so that if there is a HPA or a DCO, that you might catch it. So how are ways that you could verify the sector count? If you've just taken an image of the drive, where might you find out how many sectors are on that drive? Yes. Tab's got one. Label of the hard drive. Although, if I'm being honest with you, they started taking the sector counts off the label, which is really frustrating. So there's a second backup location. Well, the first place you should actually be looking is at your image. Yeah, spec sheets is the second one. We'll get probably a lot more luck with spec sheets nowadays than we do with the label. I wish they would keep putting them on the label because it makes it so much easier. The first place you should be checking is the actual image itself. So this is a screenshot of FTK, and what FTK will tell you is that your image has this many sectors inside of it. So the image that it took contains this many sectors. And what you want to do is compare that with the label or with the spec sheet and make sure that you're seeing the same number of sectors as you are on the drive geometry in your image. Just because you see a difference there doesn't necessarily mean the appearance of a DCO or HBA or something similar. I have had drives that are just incorrectly spec'd, as in the spec sheet reports a mistake. But we spent a lot of time working out that that was the case, and it was a call for us to go and do some checking to make sure that our image hadn't failed, that perhaps our image had conked out slightly before it needed to, and that we didn't have a correct image, or that there was indeed some hidden area on the disk that we needed to go and look for. So the sectors will give you a hint as to whether you've got a full and complete image. There are some tools we can use as well to try and detect these after the fact. So NCASE Forensic Imager, which is one of the major forensic tools, it will detect an image DCO and HBA areas natively, as long as you're using a particular write blocker that's compatible with it, so that it can pass through the ATA 6 commands that it needs to pass through. There's a Linux tool as well, or Linux tool, HD Palm, that can also detect them. Basically what this tool is doing is issuing ATA commands directly to the drive controller rather than through the BIOS. So again, if you suspect that you're seeing a HBA or a DCO, there are ways that you can go in there and try and confirm and validate those. Realistically though, you're probably not going to come across these anymore. There are easier ways to hide data on a disk than using these. But again, it's important that you know them, and it's important that you do validate your sector counts immediately after your image. Normally you'll put a sector count field on your imaging form to make sure that you capture it every time you do an image, just to drill that in and make sure it's not missed. Okay, so let's talk about the drive logical structure. So all drives will start off with, we'll start with master boot records, and then we'll get on to the newer type of structure. So at LBA, you'll start with the master boot record. So this will contain volume, locations, and sizes. So volumes are logical containers for the file systems. The important thing to note here is that a logical volume and a file system, while you often deal with them at the same time, they're not technically the same thing. So you can create a logical volume that's empty, that doesn't have a file system within it. You can create a logical volume on its own, as in a blank one with no file system in it. We often refer to them in the same breath because without putting a file system in a volume, there's not much point to it. But when it comes to forensics, it's important that you realize that there is a difference between them, that one sits within the other. So file systems sit within the volume, they take up the volume, and then they've obviously got a type. We'll probably be dealing with NTFS and FAT32 the most in the course. Again, the reality is most people still use Windows-based machines, and these two file systems are still the most prominent. You will come across Mac, and we'll touch on that a little bit. And the XT4 and what's Mac up to now? I forget what the name of the Mac file system's called at the moment. Until the year of Linux on the desktop. You'll be waiting for a while for that one. I think Adam. You will come across them, so it's important that you understand those as well, but the reality is you'll really be getting your fingers deep into NTFS and FAT32 mostly throughout your career, because they're still the majority of devices. So I wanted to touch on clusters as well. So we said that sectors are the smallest addressable bit of or chunk of space at the physical layer on the drive. At a logical layer, it doesn't make sense for us to address sectors. It's just not an efficient way for file systems to deal with data allocation and storage. So when you set up a file system, you'll be asked for a cluster size, which is a group of sectors. Then the only block of allocation for a file system will be at a cluster layer rather than a sector layer. It's important to note that the way that you assign the cluster size can have an impact on potential ways that or places that data can be stored in terms of data recovery and data hiding and things of that nature, but we'll come to that a little bit later. And then finally, any space that you don't fill up with a logical volume will be unpartitioned space. So master boot records, they still exist. You'll probably still see them on smaller devices, but they do have some pretty big drawbacks, being the amount of storage that they can support. So we do tend to see the GUID partition table type of logical setup now more than the master boot record, but you'll still come across master boot records. So it sits at LBA 0. The first section, or the majority of the master boot record, is actually bootstrap code. So this is the code that when the machine's booting up, it will flick over control over to the bootable volume. So if you've got your Windows partition in the C volume, then it will do all the necessary to kick over control to that bootable volume. The interesting part for us is the next 64 bytes, which is the partition table. And that contains a max of 4 entries, which details everything about where all of the volumes sit on the drive. Initially, 4 was the limit. There was an extension to MBR called extended partitions, which I don't know if anybody ever played with those in the past, but that allowed you to have additional partitions on your drive. Some of the other big limitations, apart from the size, initially it only supported CHS addressing method, and you still see places in the MBR now for CHS addressing method rather than LBA for backwards compatibility. So the partition table, apart from the bootloader, you've got the 4 partition table entries in there. You've got a byte at the front, which is simply for whether it's active or not. You then have, as I said, a starting and an ending CHS address. This is mainly for legacy support only. It's not really used in modern systems, but it's still there taking up space within the MBR partition table. You've then got a type code. There are hundreds of different type codes that can go in there that correspond to different types of partitions, but this will be things like NTFS, it'll be things like FAT32, Linux partition types. There's a code in there that deals specifically with the GUID partition type as well when we get to talking about that. So there's a big list of different codes, but that's essentially how you tell what partition type you're dealing with. And then we've got the starting sector and the number of sectors. So that's where the partition starts on the drive and how many sectors after that it's taking up. So as we said, these are only 4-byte addresses. So that's why there's obviously a fairly small volume limitation with the way that the MBR partition table works. So because of those limitations, GUID partition tables are the ones that we're dealing with mostly these days. They're much more flexible and much more capable. So in a GUID partition table or a GUID formatted drive, you'll actually see an MBR at LBA 0 as well. This is there to ensure that older devices don't wipe when you connect them. So obviously if they just started with their own format for the GUID partition table and you connected it to an old DOS or Windows 95 device, it would detect that it's not a formatted drive and try and format it for you. So in order to avoid that, they put in what they call a protective MBR at the front there. That MBR only contains one partition in its table, and it's got a type code of EE hex. And that signifies that it's actually a GUID partition table, and you need to go and read from the following sectors in order to determine where all the partitions live. So from LBA 2 to 34 is where the partition table is, so it's much, much larger. It's taking up multiple sectors on the drive, unlike the MBR. So you can have a maximum of 128 partitions and 18 exabytes of data. So it gets rid of all those limitations that the MBR had in terms of size. In terms of the partition entries themselves, they largely contain the same type of information that the MBR does, just in more detail. So there's things in there for attribute flags, for the partition names, and you get partition GUIDs as well, so they can be uniquely identified. But essentially, it contains most of the same information that we need if we were trying to reconstruct a drive from scratch. So let's talk about modifying the partition table. So we'll use the MBR example because it's simpler for the cases, for the purposes of this exercise. What would happen, do you think, if I were to go in with a hex editor and remove data out of the partition table, out of that particular partition table? What would that look like to us if we load up that drive on a machine? Any guesses? Will not boot, potentially. Inactive.
Will that partition be treated as unallocated space?
Yep, unpartitioned space. We'll use the term unallocated for a separate purpose later on when we talk about partition, but it's essentially the same thing. It's space that's not being used. Yes. So to look, as far as we can see, it's unpartitioned space. What does that mean for the data sitting inside the partition? Hidden? Is it still there?
Just not referenced.
Yeah, it's all still there. Nothing's happened to it. It's just sitting there waiting for somebody to come read it. But as far as the operating system is concerned, it's just empty space. It's not going to reference it. It's not going to show it up as a partition. You're not going to see your D drive when you load this drive up.
In investigations, Tim, where you'd find these volumes just deleted?
Not in this method. There are easier ways or more sophisticated ways, but yes, hidden partitions is something I've come across. Yeah.
Yeah, it's quite satisfying to find that volume signature and then all of a sudden just see all of the folder structures appear because you've allocated it correctly.
And it's an important concept to understand as well, because this doesn't just apply to somebody intentionally hiding it. This could be somebody just deleting it because they were cleaning up their drive. So if somebody deletes a partition and creates a new one, but doesn't use that drive again, all that data is still sitting there on the drive. It's just that the operating system isn't referencing it and the file system isn't referencing it. So it's really important to know that when people do things, particularly around formatting, a quick format of a drive, all you're doing is wiping the partition table. You're not deleting data unless you do a full format, in which case you're actually writing over sectors and things of that nature. But most of the time, all you're doing is rewriting the partition table, which means that all the data still sits there, all the structures within the file system still sits there, it's just not being referenced. And if you could go in there and maybe use a forensic tool to go and rebuild that that file system, you should get all of that data back. So how could we get to unpartitioned space? There's a couple of ways. Raw disk editors, obviously, are fairly easy. So something like WinHex, or I mean, there's a whole bunch of different disk hex editors, which will let you address the sector or the cluster directly and go straight there. OS IPAs can let you get to unpartitioned space. Generally, they don't like writing to invalid spaces on disk, so they might cause throw a few more challenges or errors up in your way in order to trying to write or read from there. But obviously, driver level APIs don't care about where on the disk, whether there's a file system or a partition there, they'll read from wherever you want them to read. What could somebody store? Potentially whatever they want to. And again, I haven't actually had a case where somebody has intentionally stored data in unpartitioned space, but I have seen whole files sitting in unpartitioned space because somebody has uncleanly deleted a partition in the attempts to hide what was on there. Importantly, smaller parts of unpartitioned space are normal, right? So generally you don't end up ever completely filling a drive so that there is no unpartitioned space. But if you see large amounts, that should stick out like a sore thumb for you. If we take this example here, who can pick out the interesting part of this partition table? Where would you go looking? Yep, few people got it. So between partition 1 and partition 2, there's a 10,000 sector gap there. So depending on, and obviously this is just sectors we're looking at, so we don't know how this translates to size necessarily, but that could potentially be enough to store something quite significant if you wanted to. Also between part 2 and part 3. Now remember that the second thing is the sector count. So it's starting at 20,000 and ending at 1,020,000. So it's not the start and end. The partition has the start LBA and then how many sectors it goes on from them, not where it ends. Yeah, so if you, another task that we often do as part of our core imaging process is to look at the partition table and ensure that all of our sectors are accounted for, or at least the large majority of them are accounted for by our partition table sector counts. Again, if there's some large discrepancy there, it's something worth investigating.
Is it also worth having a look at, like, if you see the sector discrepancy, just having a look in what's in there? Like if it's all zeros versus there's actually data in there? And what
absolutely, yeah. So like scrubbing the disk is definitely something that you would probably do in that situation, right? Opening it up in a disk editor and seeking to wherever the gap is and just seeing what's in there. A large amount of the time, it might just look random data, which can be difficult, but if you're seeing things like the telltale sign of file system structure, that'd be something that you'd want to look at. If it was zeroed out, even that could be interesting to you in the fact that maybe somebody has intentionally zeroed it out. Obviously, you're not going to get any data out of it, but it would be interesting in the report to say that there was a part of the disk that was unused and zeroed out. You're probably not going to be able to get anything further than that other than a question to the person when he's on the stand, but it's still it's worth pointing out and putting in your report later on.
Yeah, what is it they say in forensics? Lack of evidence is evidence of itself. Yeah.
People generally don't like completely scrub their drives, so when I see zeroed out stuff, that normally sticks out again like a sore thumb to me if I see large areas of zeros, particularly in unusual spaces. So, I mean, obviously, it wouldn't take a huge amount of effort to write a small piece of code to go and toggle the partition table in that way, right? To try and to add and remove your partition table information on the fly so that when you boot it up, it shows up as a drive, but when somebody else boots it up, it doesn't show up as a drive. And there are a bunch of tools that go to a little bit more sophisticated measures to create hidden partitions. They do exist, they are a thing. Few things to look at is the partition table may retain traces of tampering if it's not done correctly. So if it's got weird information in the wrong spot in the partition table, that might be signs that it's been tampered with. Most file systems will have a telltale signature known as a volume boot, and we'll talk about some of their signatures next week when we go into file systems. If you see an empty space and right at the beginning of it, it has the NTFS file system header or the FAT32 file system header, there's pretty good chances there's a file system sitting there even though the OS isn't reporting it. And one technique is to run a signature search across all of Arden partition space to look for file system headers that haven't actually been incorporated into the partition table. That's a technique that some forensic tools can actually run. One thing to think about though is if the partition was also encrypted, that potentially could make it really difficult for you to detect using that technique because it's just going to look like random garble in unpartitioned space. And that's something that VeraCrypt, which used to be called TrueCrypt, actually does. And if you want to have a look at that, there's some really interesting documentation there about their hidden partitions. They have encrypted partitions, they have hidden partitions, and then they have plausibly deniable partitions. Never get that out. With the third one, the idea being that even if you were put on the stand or that it did come under forensic investigation, that there's no evidence at all that a partition existed on that drive. It's really, really interesting. So I encourage you to go have a read of that if you want to. I haven't, thankfully, had that come across, although if it did, I may not have been able to detect it anyway, so who knows. So let's talk about volume slack. So volume slack happens when you have a mismatch between the amount of data that you assign to the volume and the number of, or the size of the file system that sits within it. And it happens when your cluster size isn't evenly divisible by, when the space of the volume isn't evenly divisible by the cluster size. So for example, if you have a volume that's 100 clusters and you set your file system cluster size to 15, obviously that doesn't go into one another evenly. You've got a remainder of 10. So you've got 10 sectors that are not assigned to a cluster in that file system. So this is different to unpartitioned space. So unpartitioned space sits outside of the volume. You have your file system, and if the file system doesn't fill the entire space, then you have volume slack. So again, this is another space where two types of data can exist. You could have somebody intentionally trying to hide data there, but again, slack space is commonly a place on disk, and there's a couple of different types of slack that we'll talk about. Slack space is commonly a place on disk where you find traces of older files that were once on the disk, that once occupied that space, that now occupy slack space instead. And that's more commonly what you'll find here. The amount of data that you can store in here really depends on the cluster size. Obviously, it can't be bigger than one cluster because as soon as it was big enough to be one cluster, it will get incorporated into the file system instead. So it's typically quite a small amount of space. So you really only find trace elements of files in here, or very small files, if any. So summary, places hiding techniques, if you want to call it that so far. We've got HPAs and DCOs. You've got writing directly to unpartitioned space, deleted volumes or hidden partitions, and hiding in volume slack. So let's have a think a little bit about what acquisition techniques you would use based on what we've talked about last week and earlier today, and why and when we would use them. So what kind of incriminating evidence fits into 5KB? You'd be surprised, but you can find a lot. There's Sorry, go on, Tabs.
I was going to say, you might just find a fragment of a file.
I was just going to say that one case that I remember working on, which was a case where a person had set up a competing company while they were still working for their current company, and the thing that cracked that case was it was smaller than 5 KB, and it was simply a URL that was sitting. I can't remember whether it was sitting in volume slack or unallocated space, but that URL was the thing that cracked the case. If we didn't get that URL, we didn't discover the website that they had built, and that unlocked the keys to the rest of the case. So yeah, you can fit a lot in, or there can be a lot of incriminating evidence in a fairly small amount of space. Yep, multiple Slack spaces that combine to make something else, definitely. So you might find multiple, particularly when we get to talk about file Slack, you might find multiple fragments of the same older, larger file that occupied the space that multiple files are now occupying. So yes, the right acquisition technique. Let's have a look at the different type of imaging options we have and have a discussion around why we should use different ones. So at a high level, there's 3 different options that you've got. I mean, there's different variations on these, and we can talk about those as we find situations for them. But at a high level, you've got 3 different options, and they kind of correspond to the layers of abstraction we were talking about with the drive at the physical layer, the drive at the logical layer, and then the LEF or logical evidence file is more at the file system layer when we talk about that next week. So your physical image is when you're literally taking every bit on the drive, including the MBR, all of the partition table, everything on the drive, and creating an image of that. It's generally the preferred method because it's exhaustive. We know if we've got that, we've got absolutely everything that we can find on it. It captures every single area on the disk. It captures unpartitioned space. It captures volume slack. It captures everything. And it's supported by the expert witness format that we talked about last week. So it's got all of those lovely things like hashing and stamping in metadata built in. The logical image is the next layer down. So a logical image you can run over just a partition. So if you just wanted a single volume on the drive, you could do that with a logical image. It's similar to a physical image, and at least in that everything inside that volume, including all the slack space within the volume and all the unallocated space of the file system is included, but it doesn't include unpartitioned space, and it won't include, generally speaking, anything outside of the volume, right? So it's not going to include other volumes. It's not going to include anything except that volume. The last one is an LEF or a logical evidence file. This is more for the situation where you just want a single folder or group of folders. So you're targeting some folder or area on the disk very specifically and capturing just that. And you usually only use this in scenarios where the other 2 options are impractical. And it doesn't capture slack space at all. It doesn't capture slack, it doesn't capture unallocated. All it's going to capture is the files, the allocated files that you're after. And it requires another format. It's not supported by expert witness format. You need to use something else. So NCASE has an L01 and Access Data has an AD1 for those purposes. So looking at these images, can anyone think of why we might want to use a logical image? In what situations would it be good to use a logical image? Why would we only want a single volume?
Maybe to give you like an initial idea. You don't have to do such an extensive process. It's quick and easy.
Mm-hmm. Yep. Multi-tenant, well, yeah, cloud maybe, but multi-tenancy is definitely a reason. So so we were talking a little bit earlier about jobs where companies have gone into receivership, and I've been in situations there where they're infrastructure is shared across multiple companies in where they only own certain volumes and other companies own other volumes on that drive on a server, for instance. So we're only able to take that volume. We're not actually able to take the entire physical drive. Time is another good reason. Again, if you're dealing with really large drives and you already know that a particular volume is the only one of interest, I mean, you need to be very, very sure that you're not going to need the rest of the drive, but it will save time if you're only after the particular partition. Limited time to get evidence. Yep, definitely. Yep, so it allows you to target what you're acquiring, right? You need to be very sure that you're not going to need the full drive later. Is it possible for search warrants to not allow 4 images? I'm not sure. I haven't seen that happen before. Normally with a search warrant, once the device comes into scope, you're able to take a full copy of it. Tabs, have you had that happen before where you're not allowed to take a full copy?
I don't think it's ever that specific, a search warrant.
Yeah.
I think there are circumstances, like you say, with multi-tenancy where you can't take a physical image because you would be breaching the scope of the search warrant. But I don't think I've ever seen a search warrant be so specific to state the type of image that you are or not allowed to take.
Yep.
Just because the physical image gives you so much more information to work with, and it's a much richer source for restoring deleted data. And so when you're executing a search warrant, there's a much more higher likelihood of deleted data being more relevant to the investigation.
Yeah. And that's pretty much it. I mean, in order that you would want to do these, you would always start with the physical image. And if you can't get that, you'll go to the logical image. And if you can't get that, then you'll go to the LEF in that order. How technically descriptive are search warrants? Are they generic warrants for all sorts of evidence or specific ones written by forensics professionals? Generally, they're not written by forensics professionals. They're written by lawyers, and they don't necessarily deal with this technical level, right? They're more interested in what you're allowed, what's in scope and what's out of scope from a content perspective and from a device or asset perspective. So they'll talk about computers being in scope, but they're not going to say things like you're only allowed to take a logical image or an LEF or something like that. They won't say computers. I'll say things like digital evidence or something like that, wouldn't they, Tabs?
Yeah, something like electronic data. So they'll say, this is the matter we're investigating. You're only allowed to seize documents that relate to the matter that we're investigating. And then they'll define documents as paper-based, electronic, and then electronic data will be defined as data that is stored on any type of computer device or mobile phone device or USB device, but they won't go to the specifics around how that data can be acquired.
Okay, so not all acquisitions are going to be as simple as a single physical disk though. In fact, in most cases, you're going to be acquiring a lot of disks. So based on, and so we'll talk about we'll have a discussion about 2 different types that you're more likely to encounter now, given their prevalence, and that's going to be RAIDs and the cloud and how that impacts us. So first of all, make sure everyone's on the same page. Does everybody know what a RAID is? What is a RAID actually essentially doing? Insect spray. Yep, combining multiple hard drives for speed of reliability. Yep, combining drives. All right answers. So basically, I mean, the actual definition of a RAID is redundant array of inexpensive disks. And yes, we're basically combining a whole bunch of drives to make them appear through a layer of abstraction as a single or simple storage device at the OS layer. So to the OS, it's going to look like one or maybe a couple of big storage volumes, whereas in the background we've got, potentially tens of drives that are running that and that are working to provide either performance benefits or reliability, so that if you lose one drive, you don't lose all of your data on it. So what can people immediately think might be some of the challenges with the imaging methods that we described earlier? What would be a challenge with dealing with a RAID if you turn up to a business and they've got one of these lovely Storinator NASs? One file might be stored on physical drives, yep. The RAID array is bigger than the disks you brought, yeah, definitely. That's probably the biggest problem. Super large, yep.
We've had to bring NASs on site to be able to capture these types of data.
Yep. Yep, and actually that's a really good point when we're talking about preparation. Where you have the opportunity to understand what you're likely to be encountering on site, you should take that opportunity and explore it as much as possible. You don't want to turn up and find that you've got one of these Storinators when you get there. If you can find out what they're running beforehand, and it won't always be possible, like in the case of a search warrant, you're probably not going to know what you're going to find till you get there. But on those jobs where you do have the opportunity to talk to the IT admin before you turn up, you should definitely take that opportunity and work out what you might be encountering. Restricted to only copying part of the RAID across user data, potentially. So I think we talked about space is the big one. So if you've got a drive that's got a lot of drives in it, not only do you need to have enough storage space to cover that amount, you also got to have enough time to do it, right? If you're imaging each one of those drives individually physically, you've got to have enough time not only to store it, but to actually image it. And these things don't tend to be SSDs. They tend to be your old school spinning drives. They're much slower. And just take half the disks and you'll both be right. Yeah, okay. Well, actually, we'll talk about a similar method. Not exactly that method, but a similar method. So some of the issues that we have. So we talked about, well, some of the challenges here are also that RAID arrays can be highly vendor specific, right? So the way that these things work, it's often up to either a hardware controller, and it's often a hardware controller, to manage that abstraction layer, so that software layer of combining these drives into and presenting them to the OS in a single view. And if you don't have that specific RAID controller or that specific piece of software, it can be really difficult to put these things back together. It's not like you can take one of the drives and expect that you'll have some information. You need all the drives in order for this thing to work. And then you also need to ensure that you've got the right software or the right hardware in order to be able to reconstruct it. Other challenges. So we talked about size a lot. Depending on the configuration of the RAID as well, it can make it a really challenging task. So here you've got the same 8 terabyte RAID, but it can go anywhere from needing to capture 8 terabytes to 16 terabytes. It's going to get really large and really time consuming really quickly. Another thing to consider if you are going to go down the path of trying to reconstruct these is that the ordering of the drives need to be maintained. You need to make sure that you're putting them back, or that you know which images are for which drive, so that you can present this back in the reconstruction process. And again, if you're dealing with a vendor-specific RAID configuration rather than a standard RAID 0, 1, 5, 10, whatever, you may not actually even be able to get access to the logic that reconstructs that RAID. So a lot of RAID vendors or NAS vendors now have their own proprietary version of a RAID that is specific will only work within their enclosures, and it can be difficult to reconstruct those. So given this, how would you approach potentially imaging a RAID, considering the physical, logical, and LEF options that we've got? Would this be a reason for just taking a logical volume? Potentially. Again, you need to understand that you're sacrificing some deleted space in order to do that. You're not getting a full picture potentially. but if that might be a sacrifice that you're willing to make in the particular case that you're on, it's really a case-by-case scenario. What other options might you consider? What if you really did want to get everything? Bring your own RAID. I think that's what Tabs was saying. Sometimes you might have to bring your own NAS with you. Can you request to have the entire RAID taken? Generally not. If you're being asked to do an image, it has to stay where it is. I haven't had that suggestion before. Replace single drives one by one and let the RAID controller build you a copy. Might be a little bit time consuming to let it do that. Buy the same hardware. That's a really good suggestion. So we'll talk about that option in a second. So there are 4 options for us here. We can do physical acquisitions and then try and rebuild the array afterwards. We can do a logical acquisition and just capture the parts of the drive that we're after. But if you are doing that, you might come across some size limitations if there's one really large volume that you're trying to image, in which case you might need a NAS on site with you, as Tab suggested. You've got logical evidence file acquisition. So if your job really only relates, and there are some cases where you will know that the evidence that you're after exists in a specific folder, and you may not be interested in deleted items in this particular matter. You might try and do a logical evidence file acquisition. Again, you need to be aware that if you do that, you're not getting deleted data. You're not getting unallocated space. All you're getting is a snapshot of the files as they exist right now in that folder. And there's definitely limitations with that if you need to come back later. And then live acquisitions. So again, you might choose to, logical file acquisitions and live acquisitions are honestly about the same thing, really. This is when you might boot something up on the device. This is more talking about a server rather than a NAS, where you might actually boot the server up with a live acquisition. You might run a piece of software on the server itself in order to take the image for you. But really, that's not going to give you anything better than a logical evidence file.
It does a little bit though, doesn't it? I mean, it does do a physical acquisition, but you're not guaranteed to have consistent data when you're thinking about like RAM and so forth, or the swap space hard drive and things like that. But you do get a bit more data than a logical acquisition.
You get a little bit more, but you're right. You do run the risk of data being in flux at the time that you're imaging it. Yeah.
I mean, you can individually image the drives, but you've got to really make sure. I've been in situations where I've done both. I've done a logical acquisition and a physical acquisition, because rebuilding RAIDs is pretty finicky. Especially, like, you've got to make sure you know what level of RAID it is and stripe sizes and correct ordering, and then even then you're not guaranteed to get all the data back. So you always sort of have a backup as well and take a logical acquisition of the data just in case you can't rebuild the RAID.
Yeah, rebuilding RAIDs is a little bit of a lottery sometimes. And I'm the same as you, Tabs. Whenever I've had to deal with this, I've done both. Knowing that the physical acquisition is like the gold standard, but you also are understanding that the chances, the chances of you being able to rebuild this thing are really dependent on the particular settings that it's running, and whether it's highly proprietary or whether it's standardized, and you're not going to know that before you get back to the lab and start trying to rebuild it. So best get whatever data you can while you're there, while you have the chance.
Having said that, I mean, it does depend on the nature of the case, right? So if it's the company's gone bust and you're just doing it for posterity to make sure you've got all of the records that you would need for further, financial investigations, then a logical acquisition would be completely sufficient. But if it's an investigation where, there's something more serious going on, then even if the physical acquisition fails and you have to fall back to a logical acquisition, it goes back to being defensible in court. Nobody's going to question, why did you just go straight for the logical? You can demonstrate that you at least tried doing the physical first.
Yeah, that's right. If you take an as on site, are you allowed to use the suspect electricity? I think you would have to probably negotiate with them. Generally, if you're taking a NAS on site, you're dealing with a corporate environment where you're probably going to have access to their electricity, not like in some guy's home where you're running a massive rack inside somebody's home. I think they'd be pretty upset at that as well. That would take many hours. Yes, it does. I think Tabs mentioned something around like 24 hours for a warrant. I mean, that's just the lifetime of the warrant. I've been on many jobs that take way longer than 24 hours to complete, where people will go home on shifts in order to keep the thing running around the clock, particularly if you're worried about the physical security of the devices. This happens a lot on, as I was saying, receivership jobs where you generally are wanting to capture everything about the company and its current state. And the reason that they do that on jobs where a company goes into receivership is generally the company that's taking over to run, which is the administrator, wants to make sure that if there is any malfeasance by the owners, that they've got all the evidence there around the position of the company at the time as to why they went into administration. So a lot of jobs where I've done that kind of acquisition, we've been there for way more than 24 hours capturing the data on these servers. So reconstruction RAID options, you've got a couple of different options. If you do go down the path of taking physical images of every single drive, you've obviously got the logical reconstruction. So you're going to image all the disks individually. You're then going to reconstruct using software. So you'll take all those images, you'll put them on a computer that's running some RAID reconstruction software. So a lot of our forensic tools do this, at least at a basic level. You then, what you will probably do once you've reconstructed it is take a logical image of the data once it's in reconstructed form, so that you then have a nice image that doesn't need you to constantly have to boot up a reconstruction piece of software every time you want to access data on the drive. Depending on the size. So it's exhaustive, but it takes a really long time and it requires one image per disk in the array. So it just may not be practical as you start to get up into those really big storage NASs. And it also depends highly on the software support, right? Like for basic RAIDs and common RAID controllers, you might have some luck. But if you're dealing with something that's highly customized or highly highly corporate, you might not actually be able to find any software that supports it. Physical reconstruction is another option that I have used in the past. This is where you take an image of each of the drives, and I will say that this wasn't done on a very massive RAID. It was only done on, I think, an 8-disk RAID. But you take images of all of the physical drives. You then restore those images to brand new drives and place those drives back inside either the same device or a similar device. So that way you're not touching any of the old physical evidence, you're not touching any of the drives, you're creating mirror copies of all of those drives and then physically reconstructing them in the same device or a similar device later. Again, it's exhaustive, but it's really time consuming, especially if it's large. You're probably only going to want to do this in smaller NAS cases. And it requires that you either have a copy of the controller card that matches the original hardware or that you have access to the original device itself. It's usually a last resort option. You only usually go to this option if you really need to get access to it and you've exhausted all your other options. And then, of course, you've got booting live or doing LEF, and this is where you're making use of the existing device to access that data. It's sometimes the only practical way to deal with it. It's the fastest and creates generally the smaller images, but you need to take a lot of caution with your maintaining your chain of evidence and your forensic integrity of the images, because you are running on a live system at that point and you're not using the most forensic of options. And it doesn't capture slack space in most circumstances as well, so you're capturing the least amount of evidence of all the three options. Backup tapes, yes, Tabs just mentioned as well. Backup tapes are also an option. In fact, sometimes you might actually chase the backup tapes rather than the server itself, if that's a more viable option. Okay, last thing for the night. What challenges do cloud present us? Can anybody think if they were asked to image or to obtain evidence from something running in the cloud, what's the challenge that they would see, given with the options we've got open to us with obtaining data from stuff running in the cloud? Anyone at all? Yeah, Aussie internet. That's the first one I was going to say. Your pipes are generally the biggest problem, right? I don't think anybody's going to be pulling down a 4 terabyte image in any reasonable amount of time across Australian internet. So yes, obviously you have an even slow, like if you think that platter drives, that cylinder drives are slow, pulling images across a network is even slower and definitely going to be a big prohibitor as to what you do. So generally, you're probably not going to pull down really large images from the cloud. Legal implications, that's the other one I wanted to get to. So yes, there's some pretty big legal implications as well. We'll talk about that in a second. So you're unlikely to have access to the physical infrastructure. So nobody mentioned, obviously you can't do a physical, which is pretty obvious because it's the cloud. You can't do a physical acquisition out of the cloud. You're not going to have access to the physical device itself. And even if you did have access to their data centers, you probably wouldn't know which physical device related to the particular thing that you were running anyway, because that's not how the cloud works. That's not how data centers work. If you went to the server overseas, could you get it that way? Generally no, but sometimes we have done that in the past, as in gone overseas in order to obtain, well, generally not with cloud and large data center stuff, right? If you have something overseas that is easily obtainable, as in it's not sitting in a data center where you don't have a device that's dedicated to your cloud machine, then that's an option for you. If you're talking about something like Amazon or what's Microsoft or Azure, generally there isn't like a single device sitting somewhere in a data center that relates to your machine, right? That's not how that necessarily works. If it is, then it's an option, but generally speaking, it's not how it works. So most, since some of their own regulation probably, yes, yep, definitely. We'll talk about the jurisdictional issues on the next slide. So there's generally two options available to us, or at least the most common options that you're going to deal with. And this all relies on the fact that you have the legal right to obtain the data. The first one is you can acquire a copy of the virtual machine or virtual hard drive from the admin console. So again, this requires you to already have access to this, right? And if you're dealing in a law enforcement situation, it might be really difficult. Dealing with warrants where you've got these multi-jurisdictional issues can be really tricky. If you're dealing in a corporate space where you own the device, it's a lot easier because you're generally the administrator of your own AWS or Azure site and you have the right to pull that image down. So generally these come down in fairly nice formats like VHDs or VDIs, and most of our forensic tools can go and convert them into an image that we can use in forensic software. So they're either natively supported, so VHD is often supported by a lot of our forensic software, or you can convert them using a drive conversion tool and get them into our expert witness format or one of the other formats that we want to use. The second option is acquiring live on the cloud system. Again, this is usually a last resort and this is less forensic. So again, you need to be really careful about how you're maintaining your chain of evidence. And we talked about the bandwidth issues, right? If you're trying to pull a large amount of data over a live system, over a network, that's going to be problematic, particularly on Australian internet. And as we were talking about, data sovereignty is the thing that you really need to be clear on whether you actually have the right to access the data. Where is the data you're accessing physically located? There are laws in other jurisdictions which actually say that you can't remove data from that jurisdiction. So I'm thinking about countries like Singapore have really strong data sovereignty laws. You just can't go and remove data there easily. Even though you're accessing it remotely, like you're not physically going into the country and removing it, if the data is physically located there and you're copying it across the network, that can still count as the data leaving the jurisdiction. So are you allowed to legally remove the data from that jurisdiction? And if you did, would it have any implications for admissibility in your own jurisdiction as well, if you're obtaining it technically illegally out of jurisdiction? Have you had any issues with this, Tabs?
There you go, unmute. Yeah, actually, one case that comes to mind is we did some work for eBay Australia. And so we were only allowed to access data that was stored on Australian servers because the American arm of eBay explicitly denied us access. They said you can access anything from that's housed in Australia, but as soon as you start to access US-based data, we do not give you permission to access that. And so under legal jurisdiction laws, both here and in the US, we weren't allowed to access the data. But if they had given us permission to, it would have been completely fine. But because they actually explicitly said no, we weren't allowed to touch it. Mm. And so unfortunately, their email server was in America. So there was a lot of data that we were just legally not allowed to obtain.
Yep, and I've dealt with similar sort of issues as well with data in Indonesia as well, and having to run almost essentially having to run investigations remotely, whereby the data stays in country and all you're doing is remoting in order to conduct the investigation on their servers. And so it's something that you need to get really good and solid advice from your lawyers. Your lawyers are your friends in this situation. Lean on them to tell you what you can and can't do. Don't go out there stampeding towards collecting the data before you understand what you are and aren't allowed to do. Cool, that's all I've got for tonight. So a couple of things you can have a go at your own leisure at home. Download and open FTK. If the lawyers are wrong, are they liable? I'm going to say yes. Lawyers give you bad legal advice. They're the ones who'll take the hit for it, probably, in that situation. Open FTK Imager and try and decode your own partition table on your machine. That's something you can do at home. It's a really good thing to do at least once so you understand what that looks like and have practice at parsing out some of the data structures there. If you want to have a go at looking at a GPT partition table, do that as well. That's a slightly more complex example. And answer some questions around, what partition table types is it? What are the type codes that it's using? Are all the sectors in your current drive being used, or is there any unpartition space in your device? And can you redraw it into a diagram? That's about all I've got. There aren't any other questions? Yes, slides for this week and last week will go up onto Open Learning from tomorrow. Sorry about the first week. Live and LEF acquisitions. So often a live and a LEF will be similar. So a LEF acquisition is when you're running a piece of software that's just capturing folders. So you're often running it on a separate machine, right? So in a network situation, you would probably connect to the NAS and pull the data as an LEF across the network. You could also do it by running the software on the server as well. A live image is generally when we boot the server onto a like a USB, a removable USB. That can be difficult to do with a server. You generally only do that on a PC or a Mac because you have to take the machine offline to do it. Does that make sense? Cool. Awesome. All right, if there's no other questions. Cybersecurity lawyers, new breed. Technology lawyers are a thing, right? There are lawyers that specialize in technology space. I know the what do you call it? The stereotype is that lawyers don't know anything about technology, but there are some really good lawyers out there, particularly when you get into the specialization in this space, who know a lot about technology. And they get paid very well because of it. Awesome. All right, thanks very much, guys. We will catch you all next week.